Now, I'm not going to engage upon a wholesale forensic analysis of the credibility of each and every witness. I am long enough in the tooth to appreciate that issues of credibility and weight are not normally litigated at confirmation, but are left to trial. This case, however, is unique. And as I have said, the prosecution's star witnesses are self-confessed murderers. And most of their statements were taken by the prosecution's investigators with the assurance of limited use. Namely, that anything self-incriminating would not be used against them in proceedings at the ICC. Although Mr. Nichols will undoubtedly tell you that these agreements of limited use are not to be understood as the grant of immunity from prosecution, for all intents and purposes, they are. And I am prepared to wager that we will not see even one, not one, of these incriminating witnesses in a dock at this court, nor in a dock at any court anywhere in the world, after they have been rehoused and given protection at considerable expense to the state parties funding this court. I do not think that I would be alone either in believing that there is something morally repugnant or even questionable from a public policy standpoint to shield not only one, but a number of murderers from prosecution at the ICC just in an attempt to nail Rodrigo Duterte. Indeed, in many common law jurisdictions, the use of a self-avowed murderer to convict an alleged murderer would normally entail vetting and scrutiny of the highest order. Those words, if I'm not mistaken, come from the Crown Prosecution Service's instruction manual. Public source. In fact, I would suggest that it would normally only be approved, firstly, when it is considered of more value to have a suspected person as a witness than as a possible accused. Secondly, whether obtaining the conviction of an alleged murderer is more important than the release of a self-confessed murderer. And finally, whether it is likely that a conviction could be obtained without the cooperation of the self-confessed murderer, or a number of them. Even after this vetting process, most courts in common law jurisdictions require an evidentiary supplement before relying on the sole testimony of a cooperating criminal witness, or what is otherwise called an accomplice witness. Such an evidentiary supplement, in legal parlance, is called corroboration, and rules exist governing what may be deemed suitable corroboration. I'm pretty sure that these considerations were never considered by the prosecution, for one very simple reason. At least two of the most prominent accomplice witnesses were offered up to the prosecution on a silver platter, and I cannot say by who in open session.